Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Our news session today is dedicated to two issues which we have covered already in several of our videos: the post office scandal and the Lucy Letby case. The purpose of this session is to provide updates on the current status of these issues. Starting with the post office scandal, our news focuses mainly on the update released on the 22nd of February 2024 in relation to the new primary legislation announced by the government on the 10th of January 2024, aimed at exonerating victims of the post office scandal, and which we covered in our video Post Office Scandal when legislature, executive and judiciary fail to deliver, which you can also find in the link in the description below. However, before delving into it, we thought that perhaps it is helpful to clarify a point in relation to the discrepancy in various articles as to the total number of post office prosecutions, with some referring to 700 and others referring to 900. So what is the position? For example, if you look at the post office corporate page, it refers to 700 convictions between 1999 and 2015, whilst the BBC for the same period refers to 900 prosecutions. The reason behind the discrepancy is to be found on the prosecuting agency. In the example given, the post office is mentioning only the cases prosecuted directly by the post office as private prosecutor, whilst the BBC and other articles may include cases that were prosecuted by other agencies such as the CPS and or the DWP. According to the Telegraph, in an article published on the 11th of January 2024, the Crown Prosecution Service has admitted it may have been involved in 99 post office prosecutions involving the defective Horizon IT system, according to a leaked letter seen by the Telegraph, implying somehow that the CPS is unwilling to disclose this information. However, we felt, for fairness and balance, that this should be counter-read with two pieces of information which we have found also on open sources available, such as Google, namely a freedom of information request made by a member of the public on the 8th of January 2024, requesting to confirm the number of prosecutions of sub-postmasters brought by the CPS, where the Horizon system was part of the evidence, to which the CPS provided a response on the 5th of February 2024 as follows: the Crown Prosecution Service does not centrally collate the data specified in your request. To identify cases where the defendant is a sub-postmaster and the Horizon system was part of the evidence would require a manual review of all CPS case files at disproportionate cost. We have also found, by searching again on open sources, Google, a letter dated October 2023 where the CPS has no issue in admitting openly to Professor Hodges, who chairs the Horizon Compensation Advisory Board, that Peters and Peters, acting on behalf of the post office, has provided to the CPS details of 99 cases which they think may have been prosecuted by the CPS and may have involved evidence from the Horizon system. Whatever the position may be, identifying the exact number of cases and the prosecuting agency involved is relevant in light of the law announced by the government, expected to clear hundreds of people wrongfully convicted in the post office scandal, said to be expected by the end of July, as to understand which cases will effectively be covered by this law. What do we know so far about this law? As we've covered before and in short, on the 10th of January 2024, as a result of the mounting public pressure following the ITV drama, the headline of a combined press release by the Ministry of Justice, Alex Chalk KC, and the Prime Minister Rishi Sunak MP read, "Hundreds of innocent postmasters who were wrongfully convicted due to the Horizon scandal will have their name cleared under new laws to be brought forward by the government." We have already highlighted in that same video how we believe that an en masse action may not be the right answer. Some of the reasons were ventilated in that same video. However, we reserved our full position to a time when further details were to be revealed. That time has now come. The further details were made available in an announcement of the 22nd of February 2024. The first point to note is that it is highlighted that the government recognises the constitutional sensitivity and unprecedented nature of this legislation. The government is clear that this legislation does not set a precedent for the future relationship between executive, parliament and the judiciary. And we will deliver long overdue justice to postmasters, respectful of the separation of powers and constitutional balance. We cannot see how this is possible given that effectively the legislation is wiping out hundreds of convictions ordinarily possible only by intervention of a higher court, and in the knowing the sum of those convictions caught in the law may be in fact sound convictions. That's right, as we have already stated before, the legislation is likely to include some who were in fact rightfully convicted. How can this be in respect of the separation of powers and constitutional balance, and how can this be said to be fair to those who have been wrongfully convicted, who will never be able to prove that they are not caught in the mix with those rightfully convicted? Under a section titled Scope of Legislation, the announcement states that the scope will be defined by a set of clear and objective criteria, depending on the type of prosecutor, offence dates, offence types, the contractual or other relationship of the convicted individual to the Post Office Limited, and the use of the Horizon system at the date of the offence. In relation to the type of prosecutor, only cases prosecuted by the Post Office and the CPS will be included. This therefore will exclude cases prosecuted by the DWP, the Department for Work and Pension, which are said to have relied on evidence other than the Horizon software, and if the Horizon software was in fact used, was only to corroborate the main evidence. In relation to the type of offence, only cases involving fraud and or false accounting offences will be included. As to the offence dates, only cases originated exclusively during the time in which the Horizon system and its pilots was in operation will be included. As per the contract type, cases involving sub-postmasters or their employees, officers or family members or direct employees of the post office will be included. The announcement also confirms that the legislation will apply only to cases prosecuted in England and Wales. However, the announcement specifies that while it is for the Scottish Government and Northern Ireland Executive to decide on and progress their own approaches to the quashing of convictions, we will work with them to ensure those are compatible with the UK compensation scheme so that that compensation can be paid to victims across the whole of the UK. The announcement includes 2 further qualifications. Convictions will be quashed at the point of commencement without need for people to apply to have their convictions overturned. Outside the legislation, we shall provide a route to full, fair and rapid financial redress for quashed convictions. So, as it transpires, the legislation will not cover the most pressing issue of compensation and, most importantly, will not identify those whose convictions will be quashed. This is what legal commentator Joshua Rosenberg refers as the flaw in the ointment. He says, although the law will clear hundreds of people who were wrongfully convicted, nobody will know who they are. This is likely to introduce significant uncertainty in the path toward recovering from the moral injury suffered by those who were truly wrongfully convicted. A crucial aspect of this recovery hinges on acknowledging the endured harm, but unfortunately this acknowledgement is poised to be denied to them. Not to mention the obvious difficulty in demonstrating their innocence, as pointed out once again by Joshua Rosenberg in an example illustrated in his article. He says, let's imagine a former postmaster is seeking a job that is not open to those who have committed crime of dishonesty. A criminal record check discloses a conviction for false accounting. Ah, say the former postmaster, my conviction was quashed by the Post Office Exoneration Act 2024. However, he will not be able to prove it. Not only that, the doubt as to whether that particular individual is one of the rightfully convicted caught in the mixture is again another matter that they will not be able to prove. And what do you think? Let us know in the comments below. Also, like this video if you're finding vaguely interesting, and subscribe to this channel if you have not done so already, to help us bring to you the latest news surrounding our criminal justice system. Turning now onto our second part of our news this month, dedicated to Lucy Letby. First, let me reiterate it that we do not have inside and direct information of this case, and that we were not present at the trial. But let's remind ourselves what made us feel uneasy about this case from the outset. The long jury deliberation, the extremely technical evidence that the jury was asked to deliberate upon, issues upon which experts themselves could not agree, and the many verdicts reached by majority rather than unanimity. We have touched upon majority versus unanimous verdict in a series of videos. If you have missed them, you can find them linked in the description below. Let's remind ourselves of the specific verdicts in the Letby case. As far as we understand, there were 22 charges in total. 7 charges of murder and 15 of attempted murder. Of the 15 attempted murder charges, on 6 the jury could not reach a verdict, and on 2 the jury found Letby not guilty. She was found guilty on the remaining 7 attempted charges, and of those only 2 were reached by unanimous verdict. The remaining 5 were reached by a majority of 10-1. She is due to be retried in one of those charges, and her retrial is set for June this year. As for the 7 murders, she was found guilty of them all, but again verdicts were reached all by majority. As per her appeal, as we know, she filed an application for leave to appeal against her conviction in September 2023. As far as we are aware, her legal team have not disclosed the grounds of appeal and or whether the application includes also an application for leave to appeal against sentence. Let's remind us that her sentence was on whole order, a sentence that is rather rare, and only 3 women have received that sentence. Grounds for an appeal against sentence are that the sentence is wrong in law, manifestly excessive, or wrong in principle. As per an appeal against the conviction, the grounds of appeal must show simply that the conviction was unsafe. As already highlighted in other videos, this is all but a simple test and has been used by the Court of Appeal in a very restrictive way, only really limited to cases where there has been a clear indication of poor representation at the trial, or mistakes or misconduct of the trial judge, misdirections of the jury irregularities of bias, disclosure failures on the part of the prosecutor. However, the most common basis for a successful appeal, and the one that seems to be most successful, is fresh evidence. We are not sure whether there is any fresh evidence relied upon in the case of Lucy Letby. But why are we talking about leave, i.e. permission to appeal, rather than appeal? Well, this is because in our jurisdiction there is no automatic right to appeal against a conviction. At this stage you are an applicant, not an appellant, and you are only applying for permission to appeal. Your application for leave is initially assigned to a single judge for decision on papers. We learned on the 30th of January 2024 that a single judge refused Lucy Letby's application for permission to appeal. Applications by single judges are dealt on papers. Her lawyers have since renewed her application for permission to appeal in front of a panel of judges. This application will be heard in court. We understand that the application will be heard on the 25th of April 2024. Should her applications be granted, then a further hearing will be scheduled to hear her appeal, and she will no longer be an applicant, but she will be the appellant. If her application will be refused, this concludes her bid for an appeal. She will then have to consider whether it is appropriate to apply to the Criminal Cases Review Commission to have her case referred to the Court of Appeal. This concludes our news session for this month. I hope you have found this video useful, and if so, like it and subscribe to our channel if you have not done so already, to help us bring to you the latest news surrounding our criminal justice system insofar as it relates to our efforts of humanizing wrongful convictions. Join us again next week. We look forward usher you as we sit and rise in this unique trial.